given the time constraints we have today, Friday is a very short day, and we've got to evacuate this building by, I think, 1:45 or 10 minutes to 2. So it's really a pleasure and an honor to introduce former Chief Justice Asher Grunis, who will be giving the fourth and final keynote speech. Justice Grunis actually needs no introduction, honestly. So I will leave it here and I will ask Justice Grunis to give his speech. Thank you very much for joining us.
Okay, thank you. Okay, I'll start with a complaint about the organizers. I don't think it's fair that I have to speak after Professor Miller and Professor Coffey. It's really not fair. But I'll balance this complaint by saying that the two of you organized a beautiful conference, very interesting, very educational, and I think everyone here enjoyed it very much. And we'll meet you next time, in the next conference. Okay, during my tenure on the Israeli Supreme Court, I think I dealt with more than 200 class actions on appeal and leave to appeal. So I'll speak, what I'll say is based on my experience. It's anecdotal, it's true, but a lot of anecdotes. And I'll start with about the Concepcion case. You know, this case, with all due respect to the American Supreme Court and to the great Judge Scalia, you know, I understand this Concepcion case covers, you know, the opinion 18 pages. Yes, two of the Israelis mentioned a case of Koshilevich. I sat on that panel with Justice Meltzer and I think Justice Handel, and we wrote an opinion of the bench, 1 page, that's it, with the minority, with Justice Breyer. Yeah, it didn't take us long. I'm still amazed, but I hope you're not going to quote me. Yeah. Who knows, Trump may not allow me to enter the United States. Yeah. Anyway, I'll make my comments brief. We already heard about the statistics about the number of cases, class actions in Israel. It's simply amazing. You know, the law was enacted in 2006. The first year it was 28, I think, class actions. In 2010, 440 cases. 2012, 1,020 cases. 2014, 1,242 cases. And 2016, last year, 1,556 cases in Israel. Population, 8.5 million people. It's true, the number of lawyers we lead the world, around 60,000 lawyers, and I'll tell you, it's 1 lawyer for every 140 Israelis. The next country, Brazil, 1 to 200, and the United States, third, 1 to 240. That's one explanation, only one, for the large number of class actions in Israel. Now, I'll give you another figure. I just checked. There are 2 main courts in Israel that hear class actions, the Tel Aviv District Court and the District Court in Lod. In Tel Aviv, there are about 3 out of the 50 judges. There are 3 judges who hear most of the class actions. Now listen, one of them has on the docket 246 class actions a year, last year. The other one 248, and the third one 165. And that's in addition to about 100 or 150 regular civil cases. Okay? It's simply mind-boggling, you know. If think about it. To handle within 1 year 250 class actions. I don't know what's the statistics in the federal system. I doubt that it goes more than 2 or 3 dozens for a judge. So what really happens, you have to understand, a good portion of those class actions have no merits. Nothing behind them. And the trouble is that the judge, he or she, they have to face hundreds of cases, and just vetting, going through those 250 cases and separating the merit, those with merits, without merits, it's a huge problem. And at the end of the day, they don't have simply enough time to concentrate on those cases that have merit. That's basically the problem. And I say it from the point of view of a judge, and nobody mentioned it because you don't realize that problem. And that's a very big issue, in my opinion, in our system. Now I'll speak about other problems. It was already mentioned, the settlements of cases without merit. Why? Because the defendant's lawyer tells him, you have 3% chance to lose, let's say. 3 to 5%. That's my expert opinion. But if you lose, you're going to have to pay $500 million. So what a rational CEO would do? He would say, let's settle the case. And I saw cases where I said to myself, settlements, I said to myself, it doesn't make sense. How come they settle? But I understand why they settle. Because they simply don't want to take the risk of going all the way, and because one judge, unlike Scalia, decided to certify, and then who knows what's going to happen. Then we have another problem that's specific to Israel. We have an ethics rule whereby the lawyers cannot finance the class action. And I don't know, and no one would admit it, but I'm sure that in a good portion of a class action in Israel, the lawyers break the rule. They finance, and I understand why, because otherwise, who is going to prosecute the case? The poor client with a negative value suit, he's going to, with the 50 shekels, 100 shekels, he's going to finance the claim. There's no way in the world. And in this respect, there is a wide gap between the law on the books and the law in practice. And it's such a wide gap that I don't think it's a good idea. I have a solution, and I'll speak about it in a minute. Then we already discussed what we want to achieve with class action. We want to achieve compensation of the victims and deterrence. And especially we're talking about negative value suits, and we know that in many cases the regulator fails to act. And therefore, that's the justification for class actions. Okay, now in Israel, most of the class actions are not security cases, but consumer cases. And that's an important point. Why? Because there is a paradox with consumer cases. The larger the class, the smaller the chance that they're going to be compensated. Because it's simply very difficult to find them, to trace them. They, like you said, they don't file, and at the end of the day, they're not compensated. My colleague just told me that somebody in his family received a check for the class action for less than 2 shekels. Tell me, that makes sense? It doesn't make sense. And in term, if I received a check for 2 shekel, I'll say to myself, what is it? That's a class action? They're crazy. What is it? The administrative expenses involved in distributing the money are greater than the whole compensation, you know. Okay, and now then there is deterrence. Deterrence, I already mentioned it yesterday. Think about the problem of insurance. You know, at the end of the day, who pays? Who pays? And I'll get back to it. Now, what are some of the solutions? In Israel, in a regular monetary action, you have to pay a court fee of 2.5%. 1.25% on filing and 1.25% before the trial. Okay? Under the law, in class actions, no fee at all. No fee at all. Now, there were recently suggestions for fees for tens of thousands of shekels, which is, in my opinion, I'll say it, improper, okay? But I'm all for a modest sum, definitely for a modest sum, few thousand shekels. People, yeah, that's, you know, the whole idea behind class actions, what I said last year, the motivation of greed. Now, rational people would think twice if they have to pay court fee of several thousand shekels before they bring a meritless action. Okay, that's now we have the problem, the other problem that I mentioned of the ethics rules, that it's breached, in my opinion, in almost every case. And in addition, under Israeli law, the plaintiff must prove that he or she, that they have a personal cause of action. Okay, now the lawyers look for the clients. And in order to solve this problem, I would get rid of the requirement of a personal cause of action. Because what do you need it? You don't need it when you think about the justification for in negative value suits, for example. You know, what, the lawyer has to look for someone just, it's very artificial. Why should we have it? But to balance it, I would institute something else. Loser pays. Maybe not the actual loss, the actual what the defendant had to pay, but a reasonable sum in case of a loss. If the plaintiff, the lawyer plaintiff, loses the case. Then I mentioned earlier what I think is missing in this system of class actions. It's the personal liability of the actual wrongdoers. People mentioned here Volkswagen, VW. I ask you, at the end of the day, who is going to pay for this billions of euros, shekels, dollars, whatever? Who is going to pay? At the end of the day, the shareholders of VW. Are they responsible for anything? What about the executives, those really responsible for the fraud? They have to pay. And again, remember the insurance. So why? We have such a somewhat similar problem in Israel. In Israel, a good chunk of the class actions are brought against public bodies like municipalities. I give this example. Let's take municipal taxes are raised by the municipality, okay? And something in the procedure is wrong, and someone after 2 years, after the municipality collected the taxes, after 2-3 years, somebody brings a class action against the municipality for the return of the excess municipal tax. Now, let's assume that it covers all residents paid too much. Who's going to pay? and the action is successful, who's going to pay? There is the group, the class, that's the members of the class who are going to get the money back are almost the same people who are going to finance the compensation. Sometimes it happens in U.S. in class action in the security field. You know, at the end of the day, in a security action, who is going to be compensated? The shareholders. And who's going to pay the money? The shareholders at the end of the day. So we have to think, that's a problem. It's a joke, in my opinion, in such cases where both classes are, the members are the same, almost the same or almost the same. There's no logic, except from the lawyer's point of view, obviously, for such a class action. Okay, and I know it's late, and I'll conclude by saying that I think this idea of a class action, in theory, it's an excellent procedural, even substantive tool. When you think about negative value suits, therefore the Concepcion case is, excuse me, it doesn't make sense, you know, because after the Concepcion, who is going to go to arbitration for $50, you know? So the idea behind class actions, I think it's a great idea. But when you go to the particulars, then we have to think a lot, and we have to make some adjustments. Now, the final word is about the American bill. You know, they could have said, Congress or the House should have said, we kill class actions. But they're afraid, apparently, to do it, so they do it in such a way, even in Israel it wouldn't happen. Okay, Shabbat Shalom to all of you.
Please, please wait, we have the final panel now. Hans, where are you, Hans and Geraint? Eric, the same?
Yeah. This question
Okay, this is our last panel. We have the three co-organizers of the event here. Professor Gad Barzilai, who used to be the dean whilst the idea came up, and he motivated us to work for this conference, and he did an excellent job in motivating us. Geraint, who lost last time our conference, and he agreed to come to this second conference and even form part of the organizers, and he and I asked together Hans to cooperate with us. So I think we have the best team of motivator to have a successful conference, together with, of course, our funders from abroad and from Israel. Please, Gadi.
So I'm actually the guy who may prevent you from enjoying Shabbat. And my first name is Gad, and I don't want you to submit class actions against God. So by mistake. So I will actually save you the whole spiel about talking about University of Haifa. Just maybe a short footnote. In Israel we have 57 academic institutions, and University of Haifa is considered to be one of the cutting-edge research institutions. I really would like, in a very brief way, to make a few notes about the lectures and the panels. I couldn't come yesterday because of my Senate commitments. Remind me that once Kissinger was asked why he moved from Harvard to the government, he said, I'm done with politics. So just a few comments about class action from my perspective as a scholar of law and society. So I think that one convergence is this convergence between capitalism, because we are talking about capitalism, we are talking about free markets economy, judicialization, namely the expansion of courts and judiciaries around the globe, and obviously corporations, because however you look into it, class action is targeting cooperation, and for some good reasons. Now, it seems to me that in this convergence of capitalism, judicialization, and corporations, the main dilemma, and I leave it as a dilemma, is whether class action can really mitigate or bridge over the tension between a client and a corporation. You know, like in a battlefield, the legal field is also a sort of a battlefield, and it's an asymmetrical battlefield. It's a completely asymmetrical between large corporations. Some of the corporations are international or transnational, and some of the clients who really don't have any power or any legal chance against the big corporations. And this is a really dilemma. Are we talking about a legal product, class action, who can help us to bridge over the troubled water and over conflicts which are embedded in asymmetrical legal conflicts? So this is, I think, one issue which is probably highly controversial between the different panelists and panels. The second issue, and by the way, as Chief Justice Grunis mentioned, Israelis are very interested in that because we have the highest number of lawyers per capita. I've published some comparative studies with about 40 political systems, and in a country of 8.5 million citizens, you have about 77,000 lawyers. 86% of the lawyers in Israel are graduates of private colleges of law. The second issue is the issue of legal mobilization. This is how law and society scholars are calling the convergence of social media and legal battles. And as we heard, some of the legal offices are using Facebook, Twitter, as a way to organize lawsuits of class action. It has advantages, it has disadvantages. One of the big questions which I'm not sure that we addressed in this conference, are class action a mechanism which leads to better legislation? Because law, it's not only about court. I mean, the legal field should be court-decentered. Law, it's also about legislation, and it's an interesting theoretical and empirical question whether class action are really moving and creating and generating a better legislation. Last and not least, I think that, you know, at the end of the day, it's a dilemma whether class action create a better society. So first of all, I think that there are differences between European perspective and North American perspective because of various issues which were mentioned. But I think that this is in a way also a challenge for scholars. So let me give you just an example. In law and society, we had this classical question, is cause lawyering good for society? And I used to say, well, cause lawyers might be problematic, but it's much better than cause liars. So it depends what are you comparing with. I mean, since we are in an age where national sovereignty is in a crisis, and since globalization is still unclear phenomena for us, and since regulatory systems, also in Israel, are often completely inefficient, do we have a better choice than class action? But then, obviously, there are other issues of admissibility, contingency fees, greedy lawyers, which are becoming part of the picture, and this is a real dilemma, and I think that at least the panels which I heard today and great lectures are actually alluding to that kind of a dilemma. So let me express again my gratitude to Dr. Rabia Assi, Dr. Ariel Flavian, Lily Fesh-Bishor, who made all the logistics. Thanks again for you, our guests from overseas. I wish you pleasant flight back home. Thanks to the Supreme Court Justices, Chief Justice Grunis and Justice Meltzer for coming. And thanks for the offices and the supporter of this conference. This is a second conference in a row with different kind of dilemma, and I guess that we are all expecting the third one as well. Thanks.
Okay, in 3 minutes I'm going to try to be polite, grumpy and optimistic. Polite, Ariel, many thanks for organising this conference. I'm very pleased with both alumni of the same university, Brunel in London, so it's great to be here with you. And Rabea, also thank you for all your work and for having your daughter, who's the best behaved person at the dinner last night. So those were wonderful things. Apologies again for being ill, and you've heard me coughing and spluttering a lot. Many people say that's better than hear me speak, so please accept my apologies for that. Be a little bit grumpy. I think that one of the things that struck me was that sometimes we didn't really get out of our own systems. Yes, I think that's very hard to do as lawyers. We tend to think about our own systems a lot, and at times I thought that what we need to do is use the base of our knowledge now to actually try to learn from one another. I think, Eric, when you started talking this morning and you said yesterday your message was how bad the European system was and how we needed to adopt the American system, my message from yesterday, because I listened, that's the great thing about being ill, you listen rather than speak, my lesson was the American system was broken, and maybe we needed to see how that we could put that right in different ways. And the idea the two systems are converging, but they should converge and not just pass each other, I think. And so I think we need to sort of deepen the dialogue between the different systems. Optimistically, I think we've got a good base to do that. I think Arthur Miller touched on one point where he said to some of the American lawyers, well, you've got to take some responsibility for where we are. You've been in the trough for too long now. You've got to think about new ways of doing this sort of lawyering. We have that lesson in the UK as well. I think we lost legal aid because in part at least, because many of our lawyers were treated as a gravy train. They were taking the money too easily, not giving enough return for it. The same thing happened in Australia, I think. And then I think we have the basis for this sort of discussion. I was thinking after Professor Coffey's talk today, are we actually letting this American model into Europe by the back door? Is that what we want? Is it right? Should we take control of it? If it's going to happen, should it be done on our terms rather than just allow some capital markets to sort of process our systems? And also there's things that we can give back to America. I think the mandatory arbitration clause is an interesting discussion, but maybe we should take the agenda there and say, actually, it's very noticeable that in Europe, arbitration is seen as a very positive thing. In Europe, we say arbitration is a positive alternative for consumers, that we don't want people to go into courts for small amounts if we can help it. Let's give them an option to do it in a way which doesn't expose them to high costs. Normally it's free for consumers and still leaves the option for going to court if you can't get proper redress. So I think actually we've got a lot of points to discuss from the knowledge base we got going forward, and I hope we have the third conference. I think there's a bidding competition like the Olympics now, but Florence is obviously the front runner in this bid. So I think the last word is probably going to go to Hans now.
Okay. First of all, thanks. I think these were two impressive and wonderful days. Very intense. I highly appreciated it. What I would like to stress here, and I liked your starting point, Arthur, yesterday. I think we are talking about public interest litigation. I like this book from Joel Handler very much. It's one of the most impressive books that I've read in my life, I have to say. And that we are talking about policy and we are talking about politics here. And I would, you're certainly familiar with this wonderful exchange of letters with between Paradise and Rawls, and that is the question of what kind of society do we want to live in. Yeah, and I think what we have seen three models here overstated. They're starting with our hosts. We have the Israeli and Canadian version of class action, so the soft version, so to say, of the American one. Then we have the hard American one, and then we have the messy European one. I was wondering again yesterday, what kind of story would you tell about Europe? We always like to hear success stories, yeah? So, like the one you started yesterday. We like looking back, in particular when we get older, we like to look back and to dream of the good old times. But I think the European story is not so bad as it looks like, but it deserves a deeper look. And here I would only stress 2 points. We can still learn from the United States in 2 ways. I think we are lacking, Stefan, you made a good effort to just show the cases, but what we do not have is, for instance, what Joshua said yesterday and reported on the antitrust cases. We do not have a solid knowledge on the type of litigation we have in Europe, in continental Europe, and really on the socio-legal context, on the economic effects that doesn't exist. We have only very crude statistics, and here we can learn, and that's the first thing to do, I think also for American class action lawyers, because that's the best way to learn how the system works. Maybe they should finance that project. And for the future, what I think is necessary, we have to look into the interplay. We have to look, when I listen to the Volkswagen case and what's going on in the United States, yeah, but there's also the Federal Trade Commission. There are a number of agencies involved. What is their role in the game, and what is the interaction here? And I think that's needed, and I could give you a number of examples in Europe where only a holistic perspective would tell you the full story. And there again, the society comes in. Yeah. So what counts in the end? It's not that people get 50 shekel or 50 cent back or whatever, but that's really, I think, whether peace, in a way, social peace is achieved, and whether litigation is really the only means, or whether also additional strategies are needed. And in terms of litigation, well, I was impressed by the morning session. And I was wondering to what extent the next step in the conference series would also to engage into a kind of really mutual learning process. I found it interesting to see when I listened to Marco and the others, so how to prepare a case, yeah? What can be learned here? And there is still a very practical, down-to-earth dimension beyond the huge picture. So thank you all for coming here, and thank you for inviting me and for being at that wonderful place, and happy week, no, Shabbat, that's the right word to say. Thank you.
Nice to meet you. Yeah, next time.